Boom. Hey everyone, how are you doing? How's everyone doing on this fine Sunday night? Somebody said I'm late. I am, I guess, a minute late. Um, yeah, I just finished up getting a ferment into the closet because that's really where they're best left. So I have two things that are being fermented. One is a salsa, and the other is lime, and the lime is basically somebody said, is it a drink? It's not going to be a drink. It is likely to be a condiment of some variety. It might be, so it's lime plus a whole bunch of chilies plus garlic plus onion plus it's gonna be something awesome. So I hope I am going to be after this is done, I'm going to be, oh, hey, Pixie. That's the Crap Goth Pixie. Go check out her channel. Hit the subscribe button. She is wonderful. So basically, the idea is I'm trying out an experiment with a hot sauce that uses some unusual flavors. So I can't really say everything that went into it, but it should be hopefully something. I'm hoping for something special. It might be something special in a bad way, but we're gonna see what we can do. All right, so what's on the agenda for today? It's Alec Baldwin, and Alec Baldwin, as you know, is the second defendant in the shootings related to Helena Hutchins' death on Rust. So Hannah Gutierrez-Reed was already tried, already convicted, and already sentenced to the maximum of 18 months, which I don't know that I've seen some people saying, oh, well, that means that Baldwin should be looking at 18 months. And I can guarantee Baldwin is probably not getting 18 months because hopefully Baldwin will be smarter than to say some stupid things online. So, Lisa H., hope you wrote down what you put in it. Fun story about that. No, I didn't. So, Eric, you're going on a timeout for a moment because we're not doing that. We're not going to hassle people. That's not cool. So, come back when you're better to be or ready to be better behaved. So, there are two things to sort of cover today. Somebody says, do I own sweats? I do. I just don't know where they are. I don't usually wear them. This is how I usually dress, sometimes even to go like running. We have a couple of different things to cover today. The first one we're going to cover is the latest filings in the case. Not really the latest because some new cases have come out, but we're going to cover we're going to cover a recent filing. It was June 17th, 2024. And the reason why we're going to cover this one is that it's legally interesting. There's all sorts of legal issues to talk about. And it's also got a whole lot of shade. And so we're going to talk about the shade and the all of that because, yeah. And because it's summer, we're going to enjoy a nice cold drink. And all right. So let's pull this up here. Sorry, it's just going to take me a moment here. All right. So what do we got here? We've got state's notice of intent. Let me see if I can do that to sort of move it over. Actually kind of worked all right. State's notice of intent to introduce other acts evidence. I'm going to shrink me down a little bit. So there we go. That's just perfect. Other acts evidence as intrinsic evidence or in the alternative pursuant to Rule 11404B. They're going to go through the test for all of that in a bit. So somebody says those Moscow mules must not be horrible. They were actually good enough that we bought another box. So my wife and I got through the first box and we're like, let's get another one of those. Those were actually pretty decent. I also bought some mint to make mojitos. So That'll be nice. I'm planning on doing that tomorrow evening. I'm going to have a mojito. It's going to be delightful. So what does it mean to introduce other acts evidence? Well, often you've got an accused person who has done some horrible things, and those horrible things can vary, right? So let's give an example here. Let's say you've got a guy who has killed 12 people, and now he's on trial for killing a 13th person. And the prosecution would probably really, really want to use those other 12 murders as evidence in their trial for the 13th murder, right? Baker's dozen. So the problem is that this is normally precluded. Normally, you can't just bring in evidence that somebody did bad things unless there's some real connection. And the real connection isn't just that the person is bad. It's got to be something else. And this is because of the rule against bringing in character evidence. So character evidence is inadmissible with an exception. So character evidence is any evidence to say, like, this person either couldn't have done it or definitely did do it because they're a bad person. So it's inadmissible unless the defense chooses to put it in issue. So if the defense says, my client would never have committed this horrible crime because he's such a good person, then after that, the prosecution can bring in a bunch of evidence to say, no, he's actually a terrible human being. And normally you don't want to call character evidence as the defense. And the reason why is because no matter how sainted you think your client is, and no matter how sainted you think you are, they're going to bring in everybody who says differently. And those people may have all sorts of things. So I generally think I'm a pretty good guy. I generally think I'm decent, but I'm not perfect. And so if I brought in character evidence, I'm sure they'd call, like, Scott Cardinal to say that I suck. And, he's got his reasons, and that's mostly because he sucks, but they could call him as a witness. They could call Mr. Tican, who thinks I'm awful because he also apparently wants to kill me. They could call in, every messy breakup. I haven't really had messy breakups, or I don't really have exes who I'm like, ooh, that person is terrible. So yeah. And no matter how good you think you are, they will pull in evidence to say that you are not. So that's a thing, right? Everybody has something somewhere that could be used against them as bad character. And the reason why bad character evidence is not normally allowed, you might be saying, why don't we have trials on your reputation? Why don't we have these things? Well, it's because they used to abuse the hell out of it. And the way they used to abuse the hell out of it, Blythe, I will tell you, I don't. And I can tell you why. He's not a good guy. He's not a good guy at all. So, all right. So, what they used to do is, let's say there was a horrible murder, right? Somebody has been killed and there are no witnesses. And this is in the era where there wasn't cameras, there wasn't anything. So really, you needed witnesses if you wanted to possibly get a conviction, right? But, somebody's been murdered down at the docks. There's just nobody saw anything. And so what do? Well, they bring in a guy who is a terrible criminal, the guy who gets into fights and commits robberies and whatever else. And they used to put that guy up on trial, and they'd say, we as the guards, the police, we think that this guy is guilty. And the reason why we think he's guilty, and then they just list off all of the crimes, right, that this person has done. And so juries would convict on that, notwithstanding the fact that there wouldn't even be a whisper of evidence that says this particular person actually committed this particular crime. So that was a bit of a problem. That was a bit of an issue. And so that's why we've gotten rid of character evidence as a way to get to convictions. So where can you use other bad acts? Well, there's examples of this. And so one example is something where it is very distinctively a particular kind of crime. So let's imagine that there are 12 murders, and each of those murders involved a very distinctive calling card. Like, let's say the person, leaves certain signs at the crime. They write out a certain phrase on the wall, right? And that phrase hasn't been released to the public, so nobody else knows that phrase. But this guy is found in the middle of committing a 13th murder, and you find him writing that phrase out on the wall, right? So now you've got this thing where all of these murders are they have this real strong connection to each other, right? All of these murders are really strongly connected. And so it's a reasonable inference that it's one person who committed all of the murders, right? So they might allow that as evidence to say all these murders would have been committed by the same person. Yeah, the Wet Bandits. All of these murders would have been committed by the same person, and therefore this person committed this murder, so we probably committed the other ones, right? That's kind of the deal. Now, in this case, that's not really what they're doing. They're trying to show basically that Baldwin was an accident waiting to happen. And we're going to talk about that because they've got a whole bunch of allegations here that they want to bring up at this court case to essentially say that it's a miracle that Baldwin didn't kill somebody sooner. Okay, let's go through this. My favorite phrase, comes now, the state of New Mexico, by its special prosecutors Carrie T. Morrissey and Erlinda O. Johnson, and hereby submits the following notice of its intent to introduce evidence of crimes, wrongs, or other acts as intrinsic evidence, or in the alternative pursuant to the rule, and in support thereof, the state submits the following. So that's just their introduction. So, introduction. Sometime prior to October 2021, the defendant collaborated with director Joel Souza in the writing and production of the screenplay Rust, which eventually began filming in New Mexico on October 6, 2021. The defendant was one of the film's producers. According to evidence, the defendant arrived in Santa Fe, New Mexico sometime before October 12th to begin acting as the leading actor in the film. Prior to the filming, the defendant had asked to be assigned the biggest gun available. So, the whole big gun thing has been disproved, but that study was really among gun owners. I don't know if it applies to guys on film sets who are I need the biggest gun you've got. So he was assigned an 1873 replica revolver manufactured by Pieta Firearms. Between October 12th and October 21st, the defendant was involved in various scenes wherein the defendant, 1, used his gun as a pointer directing crew members. Okay, let's talk a little bit about the rules of gun safety. So, there are some basic rules about gun safety. Miss Scarlett, there totally was, actually. There was. Just basically to say that gun owners tended to have larger bits, not smaller bits. So, okay. I think that they were actually measured. So, Anyway, that's a side note. So there are 4 basic rules of gun safety. Rule number 1, assume that the gun is always loaded, right? Because you don't know if it's loaded or not, so you assume that it is. Rule number 2 is keep your finger off the trigger until you are ready to fire. That is because if you... The basic rule, one of the basic rules is that, or one of the things about physiology is that sometimes your fingers move in situations where you weren't really planning on that. So there's actually a video that I'm thinking of talking about where a police officer had her finger on the trigger and then she begins running after somebody. And because she begins running after them, the gun goes off in her hand. It's a gun safety fail. So rule number 3, don't point the gun at anything you're not willing to shoot. And so that means you need to be careful of your muzzle at all times, right? So if we imagine that this bottle of hot sauce is a gun, you don't want to point it like at your face. And you don't want to point it at your friend's face. And you don't want to point it at anywhere else, right? You tend to keep guns like muzzle up or, so forth to minimize the harm. In theory, if your gun goes off by some magic miracle, because you're following the other rules, so it shouldn't go off. But if it does, nobody should die, right? And then the final rule is be sure of your target and what is beyond it. And so what that means is that, let's say you're hunting. If you see something and you think it might be a deer, you don't pull the trigger. You don't pull the trigger unless you're sure it's a deer. And you don't pull the trigger unless you're sure that not only is it a deer, but that bullet is going to come to a stop somewhere safe. Because let's say it is a deer that you're looking at. But behind that is a small child who thinks that the deer is cool and is trying to take a picture. Well, you don't want to shoot the kid, right? That is a thing. Simon Ramon, the gun was supposed to be loaded with dummy rounds. Actors are allowed to pull the trigger on prop guns with dummy rounds. That isn't reckless. They're not allowed to pull the trigger unless they're supposed to be pulling the trigger for the scene, which he wasn't. It wasn't for the scene, so he wasn't allowed to be pulling the trigger in that moment. Everyone agrees with, on that. And the other thing is he didn't check. He blew off the checks. He blew off every safety rule and safety procedure. So not so much. Yeah, this is the other thing. Don't use your scope to look for deer. Use binoculars and then, yeah. All right. So used his gun as a pointer directing crew members is a major safety failure. Do not point your gun at things you're not willing to kill. And hopefully he's not willing to kill like the random crew member, right? The random crew member didn't do anything. It's not a self-defense situation. He should not be pointing it at them. 2, discharge the revolver after the filming was over and cut was called in violation of rules governing the safe handling of firearms on set. Again, you can't just pull the trigger whenever you want to if you're on a film set and the instant cut is called. You don't get to pull the trigger anymore. You got to stop. So 3, the defendant shot several scenes wherein he placed his finger on the trigger of the revolver where the scene did not require any shooting of the firearm. Again, not a safe thing to do. Not cool to do. 4, rush the armor to reload and crew members to work at a faster pace. So basically encouraging people to not be safe. So 5, was inattentive during the firearms training conducted by Ms. Gutierrez and was distracted by texting /FaceTiming family members and making videos for his family's enjoyment. The evidence to support this is witness testimony and the video evidence in the last bulleted paragraph below. So, oh, shoot, I am sorry, guys. I forgot to show you all the text. We're going to keep going, but yeah. I did a video where I covered this video, where I covered him making this video for his family's enjoyment. There is no way, there is no reason why he should have been handling the, handling the firearm in those circumstances. Yeah, he isn't being charged with being not cool. He's being charged with being reckless. Pointing a gun at people on a film set when you don't need to point the gun at them is reckless. Shooting the gun in situations where you are not supposed to be shooting the gun is reckless. Doing random shooting at people at close range. The armorer actually noted that was unsafe. What he was doing is reckless. Like, there's a ton of recklessness to be had here. He just didn't give a damn about the safety rules at all, from what we've seen. So 6, engaged in horseplay with the revolver while making videos during his firearms training while using pull load blanks. I think that's supposed to be full load blanks as opposed to pull. But you don't play with the guns, right? Playing with the guns is kind of the definition of being reckless with firearms. They're not toys. You treat them responsibly. You don't just mess around with them. 7, displayed erratic and aggressive behavior during the filming of Rust that created potential safety concerns. 8, displayed reckless behavior as it related to the use of a firearm, such as pointing it and firing a blank round at a crew member while using that crew member as a line of sight at his perceived target. If you want to talk reckless, pointing a gun loaded with a blank at a crew member is reckless. Yeah, recklessness is not the same as negligence, but you going to tell me, Simone, that pointing a gun that you know to be loaded with a blank at a crew member and firing it at them is not reckless? You going to tell me that's not reckless? That's reckless. Simone says, these are all examples of negligence, not recklessness. I am sorry. Anybody who points a gun and fires it, well, loaded with a blank or otherwise, at another person is reckless, and frankly is going to get an absolute smackdown if you do that at a range. If I went at a range and I was like, I loaded a blank and I pulled it and fired it at somebody, I would be in cuffs before the end of the day. So no, that is absolutely not negligent. That is reckless. Sorry. Now, that recklessness didn't kill anybody, but it's certainly reckless as hell, because all it takes is a little bit of a little bit of crap gets into that gun, and now you've killed somebody. Little bit of gravel gets in there, and boom, that person's dead. So, yep. All right. So, and 9, after October 21st, 2021, was insistent that he not be required to follow safety recommendations made by film set safety experts on the continuation of the filming of Rust in Montana. So he still didn't want to have to follow the rules. All right. Yeah, and one of the most famous film deaths was a blank. Absolutely. So they want to use the following pieces of evidence to prove the above conduct. So here's what they have that they're going to try to use to prove it. At least what they say they have. I mean, they may not actually be able to deliver on all of this, right? These are the allegations of the government, but this is what they say they have. So on October 21st, 2021, minutes before the 911 call was made reporting the shooting of Mr. Souza and Ms. Hutchins, Mr. Baldwin was photographed by Karen Kuhn manipulating his prop gun. He appears to have his finger inside the trigger guard and his thumb on the hammer. Upon information and belief, Ms. Gutierrez was not present to supervise his handling of the gun. Here's the thing. You want to argue that you are on a film set. The instant you're not following the film set safety rules, which he ought to have known because he bragged about knowing all of the rules, and then you don't get to say, oh, I'm just on a film set, right? The instant you start screwing around doing your own stuff, it's a little bit of a different scenario there. So on October 21st, 2021, prior to lunch, Mammy Mitchell took a cell phone video of Mr. Baldwin wherein he appears to cock the gun and possibly pull the trigger. Again, this is something he's not allowed to do unless the filming calls for it. You don't just pull the trigger. And I can tell you that I have spoken to multiple film armorers, and they have said, basically, you pull that crap on the set of a film, you're going home. You're out. That's it. Like you don't get to do that. They've said that, for instance, they've taken actors' guns away, and one film armorer, who I'm not going to name, they have a squirt gun that is bright pink and shaped very, very specifically like a portion of the male anatomy. And so, because of that, that is something that they hand to people who are, not there. So it is magically safe to pull a trigger when camera is rolling, but not safe when someone says cut. Seriously, the safety rules are there. If you are circumventing the safety rules, then you're no longer within the safety rules. But absolutely, there is a huge difference between this scene has been lined up. We have a safe line. We have a safe path. All of this is planned out, and we have a safe, this is done safely. We've tricked the angle so it's not pointing directly at somebody. Nobody's in the line of fire, or we have plexiglass shields that are, that will protect people, versus I'm just fucking around. The instant you're just fucking around, that's a different thing, right? I could tell you, I do fireworks, occasionally. And so there's a huge difference between we are setting the fireworks off at the specified time and the specified, way in accordance with all of the safety planning and so forth, versus I was bored, so I decided to just, light something up and just see what happens. That's a huge difference, right? Huge difference. So, yeah. There is a giant difference between I'm doing this in accordance with the safety rules versus I'm just goofing off with a gun. All right. So in video, bunch of numbers. Prior to lunch, there's a set video wherein Mr. Baldwin is asked to look at the camera and pull his gun and point his gun in the direction of camera left. Mr. Baldwin is not instructed to cock the gun, but he cocks the gun despite not being asked to cock the gun. There is some evidence that he also pulls the trigger of the gun, which, again, not supposed to do. In another video, he can be seen exercising complete control over the crew and screaming at the crew to be quiet. This is going to be an argument against his notion that he is just a, like he's not really a real producer. Using fireworks when bored is illegal? Lols, you need better analogies, man. The fireworks I'm talking about, you bet it is. Because we're talking about fireworks that are like the size of your head and which can absolutely kill you real fast. So you would get in some trouble if you just decided to fuck around with those. So, all right. In video listed, Mr. Baldwin exercised complete control over the set by stopping the acting sequence during the filming of a scene with the minor child actor after his gun appears to have become caught on his microphone wire. Mr. Baldwin can be heard cussing loudly while glaring at the crew. Again, this is to show that he is in control, that he is, that he is getting to run things. So, yeah. In video, whatever, Mr. Baldwin can be seen using his gun as a pointer during a time that there's no acting sequence. Now, this is partially Hannah's fault, because when there's no acting sequence, they should absolutely be taking the guns away. Like pro-grade fireworks. Yes, pro-grade fireworks. Big fireworks. I think the biggest that was on one of the shows I did was a 16-inch, and that is an incredibly large firework. So, yeah. When the incident occurred, there was 100% a rehearsal. There was nothing he was not permitted to do that he would not have been, or that he, there was nothing he was not permitted to do that he would have been permitted to do when the camera was rolling. How about pointing a gun at Helena Hutchins and firing it? Sorry, man, you're just out to lunch here. You're just wrong. So it's okay to be wrong, but you're just wrong here. And the other thing is the fact that it's a film set doesn't actually exempt them from New Mexico law. New Mexico law applies on a film set, and if New Mexico law about firearms is more strict than the film set rules, then it trumps. So if you can't point a gun at a random person or a friend of yours and pull the trigger, even if you think it's unloaded, then, if you can't do that at the gun range, if you can't do that at the grocery store, if you can't do that in the bathroom, then you can't do it on a film set. You gotta know it's unloaded, not just go, I skipped all the safety training, so good enough. So, yeah. Seen using his gun as a pointer during a time there's no action sequence. He's pointing his gun at crew members while speaking to them and fires his gun after cut was called and the scene was to stop. Again, this is behavior that is unacceptable on a film set. Unacceptable so if you're saying he's just doing things that are okay on a film set, this is stuff that should be unacceptable. So, all right. He wasn't pointing the gun in the direction of a camera. He was pointing the gun in the direction of a person. And he was reckless as to whether or not it was loaded. Because, yeah. So, he's not being charged for pointing the gun at a camera. All right. In video numbers, Mr. Baldwin can be seen shooting blank rounds in very close proximity to a camera operator. Again, there's supposed to be safe distances for for when you're firing blank rounds. And the safe distances will depend based on what kind of blanks you're using. If you're using anything, from like suicide rounds, which are suicide blanks, which are kind of an ugly term, but they have a particular use on that, or to all the way up to like full power blanks. You've got different distances that are safe rounds, right? So, you can't just goof off with that. And of course, they're going to be having experts to say, this is not okay on a film set. And Baldwin, unfortunately for Baldwin, because I don't think Baldwin would actually be, I don't think that there'd be a hope of prosecution for Mr. Baldwin, but for Mr. Baldwin repeatedly bragging and talking and so forth during filming. So, or during his police interviews, during other things, he was bragging on tape. And if he hadn't done that, I don't think he'd be facing these charges. But he did. And, yeah. Simone, I'm just going to leave you be. You can have your comments if you want me to address them at this point. toss him as a super chat, because I think we've been back and forth enough, and sorry, man. So in video bunch of numbers, Mr. Baldwin exercises complete control over the set and stops the acting sequence due to his own perceived error. Mr. Baldwin can be heard rushing the armor to reload the gun and rushing other crew members to hurry. This video also provides another view of the close distance between Mr. Baldwin and the camera operator he shoots toward in the video mentioned above, ending 666B5. In video, more bunch of numbers. I'm just going to skip saying bunch of numbers because, yep. Mr. Baldwin can be seen engaging in horseplay with his gun and pulling his gun when the scene did not call for the pulling of his gun. When he pulls his gun, the muzzle of the gun is pointed directly at another actor. So, again, not okay to use. And I can say I've spoken to a number of film armors. This notion of like it's a film set, what they're trying to establish here is that he was following none of the rules of the film sets, and in fact he was just doing his own thing, being irresponsible, being reckless with the gun. When you present this to film armors and you say, hey, this guy was pulling his gun in situations where it wasn't called for, what they'll tell you is, you know what? You should not do this, and you will be removed from the filming if this is something that you're doing, right? Just don't do it, right? You will be removed. You'll be, they'll take the gun away. And, one film armor mentioned that they had a guy who in a movie went from being a gunslinger to being a guy who uses knives because he couldn't stop like screwing around with the guns. He was playing with them. And because he wanted to play with the guns, it was like, you don't get a gun anymore. They took the gun away and the guy was then stuck with a knife. Baldwin appears to have been able to basically say the rules don't apply to me. And yeah, that is, that's kind of a thing. So in the next video, Mr. Baldwin exercises complete control over the set and stops the acting sequence during the filming of the scene. Without the scene calling for any action, Mr. Baldwin cocks and decocks his gun immediately after he has stopped the acting sequence. So again, he's playing with the guns, right? They're talking about him playing with the guns. All of this is stuff that really wasn't talked about before it came out in this motion. Baldwin was trying to, spin about how he was super safe with guns on set, super careful with guns on set, always follows the safety rules, knows the safety rules by heart, is totally is totally the paragon of safety. And yeah, yeah. I can tell you, if you're on a film set and you can get away with any of this stuff, get off that film set, because it just means that the rules are not being followed. I see somebody says, where was the line here? It was a good line. Did I lose it? Where'd it go? Somebody said, hey, yeah, firearms are not a suitable replacement for a fidget spinner. That's kind of what it sounds like he's doing, right? He's just goofing off with the guns, and you got to know what you're doing. And so in another video, the camera operator was running video and asked to see the gun in front of the camera so he could adjust the focus. There was no action sequence occurring. Action had not been called, and Mr. Baldwin had his finger on the trigger. They're going to call people to specify about, to talk about the rules of gun safety and about how you shouldn't have your finger on the trigger unless you're about to pull the trigger. So, yeah. In the next video, Mr. Baldwin presented the gun to the camera/camera operator before action had been called and asked, "Is that good for you there?" Presumably speaking to the camera operator and/or director. Again, Mr. Baldwin had his finger on the trigger unnecessarily. In another video, Mr. Baldwin can be seen screaming intermittently throughout the attempts at filming the scene. He exercises complete control over the set by stopping the acting sequence, cursing loudly, and rushing the other cast and crew. More videos might be used to demonstrate that Mr. Baldwin was cocking and decocking the gun in between scenes. Again, messing with it against the tide. I do have it, but it's in the other room. So, yeah, the knife is here. The video taken by Sarah Zachary that was provided as part of her phone download will show or be used to show that Mr. Baldwin was having videos taken during his firearms training, demonstrating his inattentiveness, and was shooting full load blanks in the direction of or in close proximity to others who also appear to be filming him. This is another example of Mr. Baldwin engaging in horseplay with his gun and firing his gun when a scene is not being filmed and for no other legitimate purpose. This is the video that shows him kind of goofing off and making a video for his kids. This is, again, super not appropriate. Luann, I wonder if Hannah will testify. We're gonna talk about that later on, right? So, in Ian's world, there's no such thing as negligence. Any gun accident that violates a gun safety rule is recklessness. My dude, if you want to start getting snippy, you're going to start getting removed. But there is a difference between negligence and recklessness. You've got sort of ordinary behavior, and then you've got negligence, and then past that somewhere, you've got recklessness. But firing a gun at random people when they are not when it's not part of the filming, you gotta know. So, Simone, you're on your last legs here when you're starting to throw shit. If you're gonna throw shit, you got to put money behind it, or else you're gone. Because I'm getting tired of that. So, yeah, no, I get that there's a difference between negligence and recklessness. This is evidence that they want to call to get towards recklessness. We haven't had the trial yet, right? So where they land on that will ultimately be a thing that is determined at trial. But, yeah. All right. The foregoing acts are intrinsic to the offense charged as conduct, which conform to a reckless mens rea, intimately or blended with the factual circumstances of the charged offense. Even if found to be other bad acts evidence pursuant to Rule 11-404B, the foregoing acts are admissible to prove lack of accident or mistake, and their probative value is not outweighed by the danger of unfair prejudice. So, what are they saying here? They're basically saying we're trying to show that his attitude and his behavior was unsafe writ large. His behavior was unsafe generally. And so this is potentially going to be used to counter things like Baldwin getting up on the stand, because, Baldwin may well testify. Certainly, Bowles thought that Baldwin is going to testify. Bowles, of course, is not really a good judge of that because, frankly, he didn't do a great job. I'm not sure he's got the best way to predict things. But Bowles thought that Baldwin's going to testify. I hope he's smart enough not to, but we'll see. So, but they're going to try to call evidence to basically say, listen, Baldwin was totally safe on a gun set. And here they want to say, no, we want to show that he was absolutely cavalier about safety. He just didn't give a shit about safety at all in circumstances where he knew other people could have been harmed, like firing blanks at other people at close proximity. And he just didn't care. So, yeah. So, argument. So now they've listed off sort of what they want to call, but yeah. So, argument. Evidence of defendant's conduct between October 21st, 12th to 21st is relevant intrinsic evidence of criminal negligence and recklessness in the commission of the charged offense. So relevant evidence means evidence having any tendency to make the existence of any material fact more or less probable than it would be without the evidence. That is kind of the general definition of relevance, right? Relevance in terms of evidence is, does it make somebody more or less likely to be guilty? Not does it prove the case, not does it disprove the case, but does it help establish the case somewhat for either side, right? For either side. So the standard for relevance is typically not super high. Relevance is kind of a low standard because the court typically wants to err on the side of hearing evidence versus not hearing evidence. So as an example of, something that might be relevant, might be, hey, this person who robbed the bank, we found, the person who robbed the bank was wearing a mask. The mask is not very well described, but they were wearing a mask. When we arrested this guy and we searched his property, we found a balaclava, right? We found a balaclava that might have been the mask. And you might say, well, that's not really strong evidence because lots of people own a balaclava, especially if you're here in Alberta where it gets cold, and a balaclava can be a really useful thing for the cold, right? But it could be sort of weak evidence, and weak evidence is still evidence, right? What would be an example of something that is completely irrelevant? Well, the same guy is accused of having robbed the bank, and so what do you find at their place? You find a giant novelty dildo, right? It is like, 3 feet long and, 8 inches around. And you might say, hey, the prosecution might say, hey, you know what? The jury's going to think really terrible things about this guy and his giant novelty dildo if it goes to trial. Like, the jury might judge this guy harshly for having that. But it doesn't actually establish anything because there's no connection between the giant novelty dildo and the bank robbery unless the robbery was somehow committed with a giant novelty dildo, or so yeah, that's sort of an example of irrelevant evidence. All right, so evidence that is not relevant is not admissible. So you wouldn't be able to call things about the giant novelty dildo. In order to determine whether evidence of other other alleged incidents is relevant and admissible under Rule 11.402, the court must carefully examine the circumstances of the other incidents to determine whether they are substantially similar to the incident in question. I.e., is this a pattern of things, or is it just a bunch of unrelated stuff? All right. So was somebody upset by the novelty dildo comment? I'll move on. So I agree it is interesting legally, but we're just going over this motion here. So you're kind of throwing unrelated shade, man. I'm not trying to give you grief here. It is a legally interesting case, and I think that there's going to be a lot of argument over the negligence versus recklessness. There's going to be a tremendous amount, but we're not there yet. We're at what evidence could they call to start getting towards recklessness? Because we'll get to negligence versus recklessness in a real way when we actually have the... And guys, don't throw shit at Simon either. We're going to get to that in a real way when it's an actual trial, right? And we'll talk about it a little bit during the motion, but the motion is just, yeah. their motion to dismiss was kind of never going to get dismissed because it's a motion to dismiss, and they almost never are. So, all right. Evidence that is directly connected to the factual circumstance of the crime and provides contextual or background information to the jury is referred to as intrinsic evidence. The evidence need not apply directly to an element of the offense to fulfill the definition. So, we're going to skip over the quotation, or maybe we won't. Because Rule 404B only limits evidence of other crimes, those extrinsic to the crime, evidence of acts or events that are part of the crime itself, or evidence essential to the context of the crime, does not fall under the other crimes limitation. And if uncharged misconduct directly proves the charged offense, it is not evidence of some other crime. So basically what they're saying is we're not charging him for any of these things. We're not charging him for pointing the gun at the crew member and shooting at the crew member. Maybe we could have, right? Maybe we could have charged him for that, right? Maybe we could have actually, but we didn't. We're not going to, because nobody died from there. It didn't, so, but they're saying it is related to his pattern of activity as to whether or not he was being reckless on the set. So, all right. Indeed, evidence of acts or events that are part of the crime itself or evidence essential to the context of the crime does not fall under the other crimes limitations and thus are admissible as intrinsic to the charged offense. This gets into all sorts of tricky scenarios because essentially people are going to argue as to whether or not this is, other crimes or whether this is intrinsic to the context. So let's give an example. Guy owes his drug dealer $100,000, right? He owes a lot of money to a drug dealer. And the drug dealer is gonna commit crimes against him if he doesn't pay it back, right? So this guy is really eager to pay back his drug dealer. So then we find out that this guy's also committed several other he's stolen a car, he's broken into a place to get money, and so forth. And then lastly, we find, and this is the actual charged offense, lastly, the guy is determined or is alleged to have murdered somebody for his watch and his wallet and whoop. I don't know if you guys can hear me right now. Did I glitch out? Okay. I don't know if I did or not because I just had a power burp. So yeah, that was interesting. So, and you guys can't see me. Okay. Can we fix that somehow? I may have to stop my camera and try to figure that out. So camera, there we go. There we go. I'm back. I'm back. So, yeah, my power glitched and, don't know why. So that was fun. So you might be trying to show the murder or the motivation for the murder in terms of this guy had a very strong incentive to commit murder and was committing, was going out and doing other things for money. Now you wouldn't be able to use that to say he's committing these other crimes, therefore, whatever else. I don't actually know if that's necessarily going to be admitted, but it's at least arguable to show like this person was really, really desperate for money and therefore might have had a motivation to murder a guy for money. So, yeah. UPS actually did a great job. Not all of my stuff is on UPS. So in this case, evidence of defendant's conduct between October the October dates basically outlined in the introductory section as it relates to the firearm at issue in this matter and its handling thereof is relevant because it is part of the crime of involuntary manslaughter as it shows defendant's recklessness or criminal negligence. Now, I'm just going to note the negligence versus criminal negligence is a very different, very different standard, right? Criminal negligence is a step above simple negligence. And, negligence is kind of anything where you fall below the standard of care. Whereas you can't necessarily be criminally convicted for falling below the standard of care. As an example of just negligence, let's say I'm driving in my car and and while I'm driving in my car, I'm eating a burger, and I drop the burger in my lap. I go, oh crap. And I take a second while I'm sweeping stuff out, out of my lap. And Vern, you don't need to announce that you're departing. It's okay. You can just go. You're sweeping the stuff out of your lap to say okay, I got stuff in, and while you're briefly distracted by that, you smash into another car, and cause a bunch of damage. Let's say nobody dies, but there's a bunch of damage to the vehicle, right? That's negligent because I shouldn't have taken my eyes off the road and so forth. It's probably not criminally negligent or reckless in the sense that it's just kind of the ordinary screw up that people have while driving. Nobody drives perfectly all the time. And this is a good example. So, police charge a guy speeding 75 in a 65 with reckless driving, then try to introduce evidence of him doing 100 the week before as proof that the 10 miles per hour speeding is reckless. That one might be a little more tough, but no, it's not a bad example. So yeah, distracted is different than reckless. All of this becomes really important. And I can say I've run trials on a recklessness standard or a criminal negligence standard. And I argue this all the time, right? Where if you've got somebody who's charged with recklessness, often your argument is, listen, this person screwed up. This person definitely made a mistake. But that mistake does not amount to, criminal liability. Just imagine a world where every single mistake you might make, if it has consequences, could be charged as a crime. And I want to also just note for that in Canada, at least, people have been charged for the consequences of their recklessness, where it's actually been reckless, even when those consequences have been to them themselves. So as an example, I watched a trial. It wasn't my trial. It was a trial I was watching. I watched a trial where this guy was driving dangerously. He was driving like an absolute jerk. He was driving insanely he was basically doing tricks. He was, all sorts of stupid stuff, right? And the problem is that he then lost control of the vehicle that he was sort of goofing off with and smacked it into a tree. And as a result of smacking the vehicle into a tree, he sustained injuries. Specifically, he lost an arm. And it was his favorite arm. It was the arm he does everything with. So, that is, that was rough. But he was charged with dangerous driving, causing bodily harm, because the bodily harm was he lost his arm, and he was convicted. And he got a lot of jail time for losing his arm. If I was the judge, I kind of would have been inclined to say, I don't think we can punish this guy as much as losing the arm already punished him. Like, that's a good lesson in and of itself. And yeah. And Simon, I see your note about saying you're not defending him. You're just arguing it's not manslaughter. You know what? I think the only reason they might get to manslaughter, and I still say he's probably more likely to be acquitted than convicted. But the only reason they might get to manslaughter is because Baldwin cannot shut up. That's the thing. I would have said that there's no prospect of conviction, but for Baldwin's repeated statements. So I still say, like, 60 to 70% chance he walks at the end of the trial. That's kind of where I lean in terms of this. But I don't know that he should walk. I don't think he should walk, but I think he would, but for his statements. So, all right. New Mexico, as well as federal courts, have ruled intrinsic evidence admissible as part of the offense. Indeed, federal law recognizes evidence that is inextricably intertwined or preliminary to the crime charged as intrinsic evidence. So intrinsic evidence is admissible to complete the story of the crime by proving the immediate context of events in time and place, and to evaluate all of the circumstances under which a defendant acted. Lots of circumstances where this could come up, right? Importantly, intrinsic evidence naturally allows the government to tell the whole story of a criminal episode. And as such, evidence that is inextricably intertwined with the evidence used to prove a crime charge is not extrinsic evidence under Rule 404B. So what you can get here is that they really, really don't want it to be extrinsic evidence. Because if it's extrinsic evidence, the test for getting it in is harsher. What was your beliefs on Hannah's likelihood to walk before the sentencing? 10 to 20%, unless the prosecution screwed up. I thought Hannah's the much easier prosecution. Hannah is the easier prosecution for the government, because it is literally her job is safety. Like, that is so. Baldwin has a role to play in safety, but he doesn't have, like, safety person in his job title, which is it's kind of a thing. So New Mexico courts have often looked to federal law for guidance on interpreting the New Mexico rules of evidence. I'm just going to note, criminal law and law in the U.S. is kind of a mess generally, because Canada, for criminal law, you've got pretty much one criminal law, right? It's Canadian criminal law. And for, like, rules of evidence, it's largely similar in every province except Quebec. But the U.S. has all sorts of states. Each state can have different rules. Each state can have different, so it can be really dramatically different if you've got one state to the other. So, yeah. I didn't even know Lawyer was having a premiere. So, yeah. I don't know how to arrange the coordination, because there's a lot of people out there, right? So, August has a good question about Quebec. Does the evidence in Quebec have to be 100% in French? No. You can testify in English in Quebec. They'll just, you actually also got a right to an English trial in Quebec. So you can have the whole trial in England. So, yep. All right, carrying on here. The committee commentary for the New Mexico Rules of Evidence indicates that the rules were amended in 2012 to be consistent with the restyling of the federal rules of evidence. this is another thing that you see in the U.S. where they there does tend to be either states will intentionally differentiate themselves from a different state or from the standard or from the ordinary, or they'll tend to harmonize. And that's sort of two directions that they'll push and pull in. And it's a whole complicated thing. So, yeah. As such, New Mexico courts look to the federal courts for guidance as to the proper application of the rules. So here, defendants' acts of handling the firearm in a reckless manner and in violation of the guides for handling firearms on a movie set, and his acts in rushing the crew during scenes, fit comfortably under the interpretation of intrinsic evidence as defined by the law. No citation. That would have been a place for a citation. Defendant's acts are relevant to evaluate all of the circumstances and state of mind of the defendant on October 21st, 2021. I would have wanted to see some citations on that, right? This is the place to back that up with some case law, and they don't. That's not fantastic. So, yeah. It is important to note that the mens rea required for involuntary manslaughter is criminal negligence. So, holding that involuntary manslaughter, whether premised upon a lawful or unlawful act, requires a showing of criminal negligence. Criminal negligence exists where the defendant acts with willful disregard of the rights or safety of others and in a manner which endangers any person or property. So, willful disregard is a little bit different than just negligence, right? It's just yeah, and I'll agree with this. So convicting the armor was always going to be a slam dunk, and if you can't convict the armor, you're going to lose against the actor. If I was the prosecution, and if they hadn't got the conviction against Hannah Gutierrez, I would have honestly turned around and dropped the charges immediately against Baldwin. It would have just been like, okay, we didn't land it against Hannah. We're not proceeding at all. So, yeah. All right. Therefore, the defendant's acts preceding the shooting are probative to the jury's determination of whether, in filming Rust and in handling the firearm in question, the defendant acted in a manner that endangered the safety of others. Accordingly, his acts are relevant to his state of mind and thus intrinsic to the charged offense. Okay, now we're starting to get to some case law. In Rigo, the defendant was charged with 4 counts of involuntary manslaughter resulting from a collision of his commercial motor vehicle with other vehicles that were stopped in a construction zone in Albuquerque, or just 40 miles west, or just west of Albuquerque. The prosecution sought to admit evidence of the defendant's prior commercial driver's license exam as probative of the involuntary manslaughter charge. The defendant drove while not physically qualified and that his conduct conformed to a reckless mens rea. This would be especially good, for instance, if his commercial driver's license exam was something that, for instance, he cheated on or he failed, and like he fails the exam and then like gives a bribe or something like that. Because that would say, okay, maybe this guy should have known that he shouldn't have been driving this vehicle. And somebody in chat had the best possible comment, which is he made a wrong turn west of Albuquerque. Classic. So they, in ruling to admit evidence of the defendant's prior driver's license record, the court noted, it is well settled that Rule 404B does not apply to other act evidence that is intrinsic to the crime charged. Intrinsic evidence is directly connected to the factual circumstance of the crime and provides contextual or background information to the jury. Extrinsic evidence, on the other hand, is extraneous and not intimately connected or blended with the factual circumstances of the charged offense. So, in this case, the defendant is charged in the alternative with involuntary manslaughter committed without due caution and circumspection, in that he committed an act with total disregard or indifference for the safety of others. His reckless or criminally negligent, and again, this is the prosecution alleging this, right? So the prosecution is, none of this is proven, this is the prosecution saying things, but they have to prove all of this at trial, right? So saying don't make it so. And again, I think the prosecution's got an uphill battle. 30 to 40% chance of winning is my guess, but that's before we've seen any of the actual evidence. And I will say, his lawyers, Baldwin's lawyers, way better than Hannah's lawyer. Way better. It's like above and beyond. When you watch them in their motions, it's you can tell that Baldwin's paying the big money and that he got what he's paying for. He's got some lawyers who are, I think they're a little bit too bombastic sometimes. They tend to sort of try to spin everything into like the world's worst conspiracy, but they're pretty good. I will give them that. So, yeah. In this case, the defendant is charged in the alternative with involuntary manslaughter committed without due caution and circumspection, in that he committed an act with total disregard or indifference for the safety of others. You can see that it's relevant. Does he have, any regard for the safety of others? His reckless or criminally negligent state of mind may be proven by his conduct in the days leading up to the shooting of Miss Hutchins. That's a grammar mistake. A little bit of proofreading there. Of Miss Hutchins on October 21st. Notably, the defendant may be convicted of involuntary manslaughter when a convergence of the proper act and state of mind requirements result in the death of an individual. So, accordingly, the defendant's acts are admissible as evidence of his reckless state of mind. So, that's argument number one. Argument number two is a fallback argument. It's basically, if you don't agree with us here, then this is how we still win. And this is one of these things that just tends to baffle non-lawyers. Non-lawyers tend to hate this because it's like, if I'm wrong about A, then here's a completely different argument about how I should still win, right? A lot of the time, non-lawyers hate this, not so much in this context, but they'll hate it in contexts where it's like, it'll be like a shooting in an alley, and they'll say, my client wasn't there, but if he was there, then it was self-defense. And they'll be like, huh? How are you arguing self-defense if you're also saying your client wasn't there? And I can tell you, I've walked into trials with the arguments potentially just like that. It's like, either did you prove my client was there? No. Did you prove it wasn't self-defense? No. Okay. So, Rule 11404B states that evidence of another crime, wrong, or act is not admissible to prove a person's character, to show that the person acted in accordance with the character, right? This is what I was talking about before, about bad character evidence. You can't say this person murdered 12 other people and therefore probably murdered person number 13 just because this person is somebody who loves murder. They just love murder. They can't get enough of murder, so they probably committed. And the problem is that obviously this person didn't murder everybody, right? So, yeah, it can't be that the person murders everybody. So, yeah. All right. But evidence of another crime or wrong or act may be admitted to prove motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. So these are relevant purposes for this. So let's say, for example, I've got a guy, he's charged with having committed a murder with, let's say something really distinctive. This thing, Macahoodle. He's charged with murdering somebody with this. And I'm going to tell you, this thing would leave some pretty distinctive injuries, right? So, what could you not show? Well, you couldn't show that this guy broke into a museum just to say this guy's a bad person who commits crimes and gets fuzzy for no reason. We got to fix that. My camera got reset, so it went back to autofocus, which is awful. So you can't say he broke into a museum to show that he's a bad person who commits crimes, and therefore probably committed the murder. But what you could possibly do is tender evidence to say this person broke into a museum and stole a macahuitl while he was there, and that because he stole this very specific weapon, that kind of suggests that maybe he was responsible for the murder with that very specific weapon. And you don't even need to be that specific. It could be this guy broke into a gun store the day before, stole a handgun. The murder was committed with a handgun the next day, and it was the same caliber. It's relevant, right? And the jury would get a limiting instruction saying you can't use this for character evidence, but you can use it for, for, in this case, like, preparation, plan, identity, those kinds of things. So thus, evidence of other acts is admissible under the rule if relevant to a material issue other than the defendant's character or propensity to commit a crime. You can't use it as propensity evidence, but you can use it as that. So I'm just going to put down here. Somebody wanted me to spell it out. It is an old, like, Aztec weapon that is basically a wooden bat with obsidian flakes in it. It is really, they're a nasty little bit of, nasty little item. All right. So evidence of prior bad acts is admissible if it is probative of a material element at issue. So basically the bad acts are, irrelevant, but something else might make them relevant, if that's a sort of helpful way of putting it. All right. Moreover, whenever the proof of another act or crime tends to prove the guilt of the person on trial, it is admissible, notwithstanding the consequences to the defendant. The state has the right to show the guilt of the defendant by any relevant fact. So they're basically saying, okay, that's we still get to get that in, even though it might suck for the defendant. So such evidence may properly be received if it is relevant to and its probative force is sufficiently great upon some material element of the crime charged which is in issue. And persons other than victims in the counts being tried were allowed to testify to dealings with defendants similar in nature to victims' dealings with defendant in order to show defendant's intent and common scheme or plan. So let's imagine, for instance, that this guy keeps somebody goes on Kijiji or Facebook Marketplace or whatever and tries to lure. I know I'm not. Oh, right. Can't see the document. Cool. And tries to lure people to a particular warehouse. And those people get weirded out and they don't go, right? So they don't, but then somebody else does go to that warehouse and gets robbed, right? So yeah. It could show that it's, that he's got a scheme. It just didn't work on this other person. So in a case of fraud, related incidents of accused acts are relevant and admissible to establish motive, absence of mistake or accident, common scheme or plan. Somebody says, why own that weapon? Because it's cool. What's an instance of mistake? So let's say, for example, that I pay a guy with a check, right? And then the guy somehow manages to cash that check twice, right? He cashes the check twice, and so I have now been ripped off, right? And so he says, oh no, it was just a mistake. Well, the thing is that if you can show that in fact he's done this to like a dozen people, and that this is what his sort of common act is, that might be relevant to show it's not a mistake, right? So, yeah. In particular, evidence of another crime that tends to undermine defendant's innocent explanation for his or her act will usually be admitted. This is a fantastic quotation for the prosecution on this one, because what is Baldwin's argument? I was following the safety rules. I was just listening to the safety people. I am totally innocent because, all I was doing was just following the safety rules. And, so they're going to say, no, you weren't. No, you weren't following the safety rules. You were ignoring the safety rules every chance you could. And so you don't get to sort of make that argument, or at least we're gonna call BS on it when you do. So, as the New Mexico Court of Appeals recognized, the admissibility of evidence of other acts does not depend on whether the evidence is potentially illegitimate evidence of character, but instead on whether there is a permissible purpose. So it can still show bad character, but so long as it's relevant in some other way, then it can go in. So, U.S. Supreme Court held that when evidence has the dual nature of legitimate evidence of an element of the charge and illegitimate evidence of character, it satisfies the rule of evidence 404B, and admissibility is determined under 403. So, and I'm going to skip over a little bit because it's getting a little repetitive here as they go over it. But yeah. Wherefore, based on the foregoing reasons, the state of New Mexico hereby notifies the defendant of its intent to introduce evidence of acts by the defendant during the filming of Rust. Now, I am going to guarantee something is going to happen. Baldwin's team is going to oppose this. There's going to be opposition to this. They're going to say, no, that is not, we don't think that's appropriate. We don't think that's good evidence. That cannot go in, and it's going to be a fight. That is 100% that is going to happen. So I don't know if that evidence will go in yet. I don't know if that is... I don't know if that's going to... we'll have to see, right? This is the argument that's going to be made, is basically we want to tender all of this evidence. And I got to say, if I was Baldwin's team, I would be fighting this. I'd be saying, this is unfair. It has no probative value. And it's just going to be super prejudicial. So, that's about it. So we'll have to see. There is no response to this that's been filed yet, but I suspect that response is going to be called fairly soon, right? So, all right, let's go, and we're going to talk a little bit about Friday. Friday, there was a motions hearing, and the judge was a little ticked, and I'm going to tell you why the judge was a little ticked. The judge was a little ticked because the judge expected that the motions hearing would be done on Friday. And you know what? It wasn't done on Friday. It was so not finished on Friday. So it's going to continue on Monday. And it's funny because the defense was like, we're going to call a bunch of additional witnesses. We're going to do all of this. And we'll see that the judge actually went, nah, bro. No, you're not going to get to do that because we're going to end this at some point, sometime. Okay, so let's have a look. We're not going to go through it in all of the detail. And the reason why is because it is like 8 hours worth of garbage. And so we're not going to go through 8 hours because it would just suck. Huh. So instead, we're going to go through it in a very limited fashion. We're going to try to cover things sort of more briefly. Okay. All right. Let's have a look here. We're going to pull this up. Hopefully, we're going to do that. We're going to do that. Actually, we're going to go. Where's full screen? I know this thing's got full screen. There we go. Full screen. There we go. Maybe I'll embiggen myself slightly. All right. So we're going to go through this in some detail. I'm going to try to give you guys a sort of overview of what happened and what the key issues are without it taking as long as all of that. Now, all right, so let's jump first to here. And hopefully this will...
The state inexplicably files a motion basically claiming that the defense has untimely state. The first is that there was a deadline for witness list disclosure that was issued by the court, and that deadline was May 6th. On May 6th, both the state and the defense filed witness lists that added new witnesses. The state added 8 witnesses, and the defense added 9, and this was on the same day. Now, later this same day, the state inexplicably files a motion basically claiming that the defense has untimely disclosed these 9 witnesses and that we have been engaging in sandbagging by adding these 9 additional witnesses, again, keeping in mind that they had just added 8 of their own on the same day. Now, the defense does not reciprocate. We don't file any motions claiming that they've been sandbagging or that they've done anything in.
So I'm just going to note, you're going to see a lot of different lawyers for the defense because they've got a whole lot of lawyers. And I'm just going to pause here and do this. Thank you, Canonical Heat, saying, thanking all the gods and goddesses, known and unknown of this place, that this isn't about Karen Reed. We'll talk a bit about Karen Reed tomorrow, I'm afraid. It just is what it is. But today, it's a break. All right, let's keep going here. So this is one of Baldwin's team, and she's explaining what her argument is.
Proper, because both parties haven't.
Oh, mic problems. I don't know why that comes up, but hopefully we fixed it.
In fact, complied with the court's order and filed their motions by May 6th. Now, on May 21st, we respond and we point out the absurdity of the state's position and of their request. On May 31st, which is a Friday, the state files a reply. And in their reply, they are still calling for exclusion.
Yes, this is the new mic.
Our 9 witnesses who
our
we
new mic
listed
cable
on the deadline of May 6th. Now, at 6:52 p.m. on May 31st, that Friday, the state also files a notice of completion of briefing, which is basically informing the court that the matter is ready to be heard. There's no withdrawal of the motion. They are still maintaining their position and their request that our 9 witnesses should be excluded, the ones that we filed on May 9th.
So state is asking
Now,
for 9 witnesses
at
to be
this point,
booted.
the defense is aware that we have 8 days that were scheduled for trial. And with 8 days scheduled for trial, the state at this point has listed nearly 50 witnesses, and the defense had 26 that were listed on our list as well.
There's no way they're getting through that many witnesses in 8 days. Not unless those witnesses are just like, hey, what's your name? And then get out of here, right? There's no way you're getting through. Yeah, that's just nuts. So, yeah.
Now, we know that there's no way that we could get through 76 witnesses in 8 days.
Correct.
That's not possible. And so trial is fast approaching. And so the defense recognizes we need to start preparing for trial. We need to start putting these resources where they need to go and be working toward trial rather than investigation. We have to switch gears. So acting in good faith and knowing the state's position with these motions that we've now filed and briefed over the course of the past month, the defense reviews the case and then makes a strategic decision that we can cut down our witness list significantly. And we proceed to file on Sunday, which was June 2nd, a written notice that we are withdrawing nearly half of our witness list.
Okay, so
and so we consent to exclude.
This is important. They say basically we're getting rid of a bunch of our witnesses, and therefore, we're good with excluding some of them. And yeah.
Exclusion of 5 of the 9 witnesses that the state has requested be excluded through their motion. And so we send a courtesy copy to the state of our notice of our intent to withdraw.
Oh, that is cool.
Those witnesses. And we also send a new witness list to the state. Less than 3 hours after we sent those copies to the state, after the state now has this insight into defense strategy, and while the state had just hours before still been standing on their motion that our witnesses should be excluded, the state turns around and less than 3 hours later files an amended witness list, adding witnesses that they still have a pending motion to exclude. That motion is still pending, and yet they file an amended witness list adding witnesses that they are still seeking to exclude per their motion. The next morning, then, the state files a notice that they are withdrawing their motion. All of a sudden, there's no prejudice. All is well. All of these things that the state had declared to the court that they would suffer as prejudice by the defense's disclosure of these witnesses on May 6th is now no more. And in fact, they want to go ahead and add some of the witnesses to their own witness list.
So I kind of like that her style, because she's got a little bit of snark, and it's very gentle snark. Whereas some of the other defense lawyers really, really lay it on heavy. And I don't think that actually does them any favors. She's very gentle with it, but it's still some snark, and I like her style.
So we find ourselves, Your Honor, in the absurd position where the state has sought exclusion of witnesses by motion. And this is not through discussion. This wasn't correspondence through emails, through phone conversations where the state says, we think you should pull these witnesses. This is through motion practice. They have represented their position to the court, and they've represented their position to the defense. And they've notified the court, this matter is now ready to be heard because it is completely briefed. And yet within
Okay, so let's talk about what they're upset about. They want to exclude some witnesses and prevent the witnesses from testifying. And the story on that is that they, the reason why they want to exclude that is they say, listen, we had these witnesses. We were going to call them. The prosecution wanted to prevent them from being able to testify. And then we decided we weren't going to call them. And then they turned around and said, oh, now we want to call them. So she's like, this isn't fair, basically. Now, she's going to run smack into a big problem. One big problem she's going to run into here. And we'll get to that. We're just going to pull ahead to the big problem that she runs smack into here. Now we're on to the prosecution, by the way. Although I got to say, the filming in the dark room, backlit, this kind of makes her look like she's in a horror movie. So when I say like, hey, you should maybe, maybe put some effort into your, into your filming scenario, this looks creepy as hell. If this was a D&D game, I'd expect her to have a stat block. So, all right.
List witnesses on our witness list. We first interview them, find out what they have to say, and then we list them on our witness list if we believe their information or the evidence they're going to present is relevant. On May 6th of this year, the state filed its witness list. The 45th witness, as the court noted, is any witness disclosed by defense, called as a witness by the defense, or listed on the defense witness list.
Boom. So when they say they didn't list these witnesses as people the prosecution would call, she says, we said we include as potential witnesses everyone who is on your list. So would a green screen be considered a business expense for a lawyer who has to do lots of video called meetings? Easy. That'd be an easy justification. So she basically says, we did tell them. We told them every single witness that was on their list was potentially a witness for us, too. So what does the court say in response to all of this? Well, you're probably guessing where this is going.
Standard that they needed to meet, rather than actually determining that they had suffered prejudice because it was merely a placeholder. So we would ask the court to grant the defense motion. Thank you, Your Honor.
Thank you for your presentations, counsel. The court makes the following ruling, which will be followed up by a written order. The court denies the expedited motion for order excluding witnesses. I did not think that the defense has demonstrated the prejudice that is required under State v. Harper. The defense was on notice that the state may call defendants' witnesses through their May 6th witness list addendum. And given this notice, the court does not find that defendant was prejudiced by the later filed June 2nd, 2024 witness list addendum.
Basically, they told you that they might call any of the witnesses on your list. So when you knocked some people off, they immediately, within 3 hours, told you, oh, we're definitely still calling these people. She says, no prejudice. You lose. Goodbye. So that was the first motion, right? And it's a clear ruling. I am a fan. So let's, I'm a fan because it's a clear ruling. Okay, let's go.
So to kind of back up, Ms. Gutierrez, as the court can see from the pleadings, was initially named on the state's witness list in February. She was then named on the defense in April, and I believe she was also named on the defendant's witness list in May.
I don't really have an option for...
She was scheduled for a pre-trial interview after...
So YouTube has been being awful with lots and lots of like Wheel of Death. So I downloaded this video. Unfortunately, that does not allow me to do faster versus slower very easily. So, and yeah, Morrissey, get off the laptop, get a camera, get the camera positioned above you, not below you, because the nostril cam is bad.
Some difficulty. And I personally intervened and set up that interview, even though it was the defendant's responsibility.
So what is this about? What is this about? She wants to... So Carrie Morrissey wants to offer use immunity to Hannah Gutierrez. And Hannah Gutierrez doesn't want the use immunity. And you might be saying, why would she not want the immunity? Well, she doesn't want it because she doesn't want to testify. And she wants to plead the fifth on as many things as she can. So basically what use immunity means is that let's imagine a world where Hannah Gutierrez wins her appeal. I don't think she's going to win her appeal, but let's imagine that she wins her appeal and she gets a new trial order. At that point, what they don't want is at the new trial, all of her testimony here gets used against her. So the use immunity is to say any of her new testimony can't be used at a retrial. But it's not a blanket immunity in the sense of like, we're not saying that if she wins the appeal, she doesn't get a retrial, right? It's only for that. So that's really what they're asking for. Now, she doesn't want the use immunity because she doesn't want to testify. And that's going to be a key factor here. So let's keep going.
So we interviewed her, and as the court can see, when we interviewed her, I would certainly argue inappropriately, her attorney instructed her to assert her Fifth Amendment privilege to questions that did not trigger.
Just a minute. Is there a reason why the attorneys are not on video? Under our rules, you're required to be on video when we're doing hearings.
She basically says, get your butt on the camera. Thank you, VM. That's very helpful.
I'm sorry, Your Honor, I just kind of lost my train of thought. So she was scheduled for a pretrial interview. We interviewed her. Mr. Bowles instructed Ms. Gutierrez to assert her Fifth Amendment privilege when questions were posed to her that didn't really trigger her Fifth Amendment privilege. The state is not seeking information from Ms. Gutierrez about her criminal conduct. The state is seeking information from Ms. Gutierrez about the criminal conduct of Mr. Baldwin.
Now, let's just talk about this because I actually think that there's a bit of an issue with this. She's going to give an example, and I'm going to attack the example.
The court can see from the transcript of the interview, at one point, Ms. Gutierrez just asserted her Fifth Amendment privilege without the assistant attorney. And when I mentioned to Mr. Bowles, I said, you're not really advising her to assert her Fifth. She's just doing it on her own. And he said, well, I think she can do that. So I
would agree that she could do that. The lawyer advises taking the Fifth, but there's no reason you can't take the Fifth, generally.
So we have Ms. Gutierrez who doesn't understand the circumstances in which she gets to assert her Fifth Amendment privilege, just asserting it, and her attorney not counseling her on that. So the bottom line is, it took a long time to schedule the pretrial interview. That's the fault of Mr. Baldwin's counsel and Ms. Gutierrez's counsel, not ours. They listed her, I believe, initially on April 19th. We requested her pretrial interview on April 21st. We didn't create any delay at all. Her interview was scheduled, and Mr. Bowles did exactly what Mr. Baldwin's counsel wanted him to do, which...
Ooh, that's a big assertion, because later on in this proceeding, I'm not going to cover it, but later on in this proceeding, they confirmed that they don't have a joint prosecution agreement. And so if Hannah is acting on Baldwin's behalf, that's a weird issue. Like, that's a whole problem. And the other thing I've got to wonder here is, like, is Hannah getting something for Baldwin?
Which was just have her assert the Fifth to everything, because they don't want her to testify. She is listed on their witness list, and they presented her for a pretrial interview, but they don't want her to testify. They want to get her statements in as exceptions to hearsay. And certainly what...
They don't want her to testify because they They want to pin, like if her statements come in as exceptions to hearsay, then only her statements can come in, and Carrie Morrissey can't explore anything else, right? So
the state is arguing to the court is that the hearsay statements that the defendant wants to present to the jury, those are statements that have to do with Ms. Gutierrez's culpability, and they are absolutely exculpatory to Mr. Baldwin. And they go to causation in this case. It's perfectly appropriate for them to present those statements. I'm not objecting to that or arguing that point at all. But what I am saying is that in turn, the state is also allowed to present testimony from Ms. Gutierrez that goes to Mr. Baldwin's culpability.
I'd agree that's fair.
She has probably more information than any other witness with regard to Mr. Baldwin's culpability. We are simply asking that we also be able to present testimony and evidence from Ms. Gutierrez. The defendant intends to do it. There's no question about it. So the first thing that needs to happen here is we need to have some kind of a question.
And if your camera can't be eye level, ideally, it should be higher up, looking at you from downwards rather than lower. My camera is there, so it's a little higher than my eyes. But above is a way better angle than below. Nobody looks good from below. Oop.
Question by question determination from the court as to which questions Ms. Gutierrez even can lawfully assert her Fifth Amendment privilege. Once the court decides, okay, this is the category of questions where I believe she can assert her Fifth Amendment privilege, then we make a determination about whether or not she should have use immunity to answer those questions. That's not terribly difficult. Her pretrial interview, as the court can see, was relatively short. I think it was 20 or 30 minutes. So we need to have a hearing. We need to have the court determine, or the court potentially could even do it from the transcript. Have the court just determine what she needs immunity for. At this point, a lot of the questions that we would ask her, she doesn't even need immunity for. She's just a normal witness. She's on the witness list. She's been interviewed. We put her on the witness stand. We ask her the questions.
So we're at 1.2, just by the way. And she's going to give an example. I think it's right here.
She's required to answer them under penalty of perjury. There's no reason when she's posed a question, for example, was Mr. Baldwin attentive during the firearms training that you provided?
Okay, the example of if Mr. Baldwin was Mr. Baldwin attentive during the firearms training? And she says there's no reason for her to assert Fifth Amendment about that. And if I was on the other side of things, I would certainly argue that that would be a proper assertion of the Fifth Amendment, because you still let Baldwin shoot. You still let Baldwin handle guns, notwithstanding the fact that he was inattentive during the firearm training. Doesn't that tend towards her recklessness? Doesn't that tend towards her, towards her guilt? I actually think her example is an awful example. I think her example is exactly something that you'd plead the Fifth about. So I actually think that would be something that could help convict Hannah. So
how does that trigger her Fifth Amendment privilege?
Just
what
explain
did your
that.
firearms training with Mr. Baldwin consist of? How does that trigger her Fifth Amendment privilege?
Because if she did crappy training, then that is also relevant. You just filed a whole thing about intrinsic acts, right? About that Baldwin being careless in other ways is relevant. So would you not say that this falls under intrinsic acts? I think this is not a great argument here.
So this is just something that we need to get ironed out so that the jury can have all of the information that the jury needs, that the jury is entitled to, and we don't create a...
So Hannah will never work on a film set. I can tell you that. She's not going to be a grip. She's not going to be craft services. Hannah Gutierrez Reed is she's burned. They're not going to let her on a film set at all in any role, right? I don't think they're going to put her in any capacity on a film set at all. So because of the felony conviction, she can't own guns, so she can't be an armorer. But like, they're not going to let her. They wouldn't let her shine boots in props or in costumes. They wouldn't let her serve sandwiches. They wouldn't let her haul equipment. They would not let her anything. She's not going to be an extra. She's not going to be like, you know, she's not even allowed to be a shelf. I don't think, right? If she applied to be a shelf, they'd be like, nah, no. So yeah, it's just, she's not, not a driver, not anything. So
situation where Ms. Gutierrez's statements only come in with regard to the exculpatory value they have for Mr. Baldwin. They also need to come in with regard to the inculpatory value that they have with regard to Mr. Baldwin. Thank you.
She might do that.
Mr. Baldwin. I mean, Bowles, sorry.
All right, so we get Bowles in this, even though Bowles is not counsel for anybody here.
Your Honor, and as a preliminary matter, Judge, can you hear me?
His internet is awful.
Yes.
Judge, I want to make sure. Okay, I'm having poor internet connectivity, so I hope this doesn't affect it. Judge, I want to start by saying that first of all, the assertion of privilege was on behalf of Ms. Gutierrez Reed, who wanted to assert her privilege. It wasn't on behalf of anybody else. She has a currently pending appeal, as this court knows, so she has a conviction that is not yet finalized, and the cases are very clear. She can invoke a privilege as to questions that may tend to incriminate her.
He's right.
I agree with the state. She cannot invoke as to all questions if those do not have a tendency to incriminate her. However,
so this is a key thing. Somebody said, how is the invocation of the Fifth Amendment limited? You can't Fifth Amendment everything, right? Fifth Amendment is only useful for things that might incriminate you. So as an example, did you murder Bob? I assert the Fifth, right? That, you know, I'd like to exercise my Fifth Amendment rights as to the question of whether or not I murdered Bob, right? This is an example, right? Not, I didn't actually murder Bob. But, you know, and like, what is your name? What is, what did you have for breakfast today? Now, in theory, what did you have for breakfast could be under Fifth Amendment privilege. Because it might be that you ate Bob for breakfast, right? If you fried up part of Bob, then you might have a Fifth Amendment argument as to why you can't say what you had for breakfast, because it would tend to incriminate you because you ate Bob. So, but you can't just use any, you know, you can't plead the Fifth about anything, right? So, yeah. Yes, in YSL, he pled the Fifth to his age.
When Ms. Gutierrez Reed invoked it on her own at the interview, Ms. Morrissey also said in the transcript, and she left that out in the interview, I think she can invoke that. So that's what happened there. That was May 14th. Your Honor, preceding May 14th, on or about May 8th, it was a confusing situation because Ms. Morrissey had told me that on a Sunday, an email that she would stipulate to unavailability, or thought she would stipulate to unavailability, so that the statements can come in through that exception. So I thought it was going to be a stipulation. Then there was confusion on the interview date. Then I had scheduling issues, so we got it set up. Next, Your Honor, on May 14th, we got the indication from Ms. Morrissey that she wanted to file a motion to force use immunity, which under Rule 5-116, this court.
Also, for those of you watching the Karen Reed trial,
Unquestionably has that authority and discretion to do that. Now, Your Honor, in a normal case, and the cases cited in that rule, Bellinger and some others, this court can force use and derivative use immunity, which I do not believe should be selective, as the state indicates, because the problem we get in there is that on cross-examination, questions may be asked, then Ms. Gutierrez-Reed may have to invoke in the middle of trial. If that were to happen, her testimony could be stricken. So I think if this court were to order use and derivative use immunity, it would have to be blanket as to the trial testimony and cross-examination, I would submit to.
So he's basically saying if you're going to order use immunity, it has to be for everything at the trial. And you know what? Morrissey's response is going to be? It's going to be yes, please.
Avoid those issues. But Your Honor, that's in the normal case. This will be most likely the most publicized trial in the history of New Mexico, or at least one of them. And because of that, we have submitted in our briefing, this is not the typical case. If Ms. Gutierrez-Reed testifies, there's no current restrictions about what could be asked of her, including on cross-examination. That testimony will undoubtedly be watched by millions of people. Currently, Ms.
I would love to get millions of people watching on my streams, but I don't think I'm going to get to millions. I think maybe I'll get to thousands. But millions would be nice. We'll see.
Gutierrez-Reed.
By the way, I am planning. I don't know whether I'll be in New Mexico for the Baldwin trial or whether I'll be doing gavel to gavel coverage. So I might be doing just full-time coverage.
Is set for trial in front of Judge Ellington in August. We have moved to continue that, Your Honor, but that is a separate matter involving alleged bringing a gun into a bar. There's no protections as to Ms. Gutierrez-Reed on that trial, because even if this court were to order use and derivative use immunity completely, that testimony she gives will be watched and heard by potential jurors, and there's really no way to prevent that. Now, the government says we can do a motion to change venue if there's an issue. But again, that raises the issue, Your Honor, this is going to be widely publicized across not only the state of New Mexico, but the country. So that's a very real concern Ms. Gutierrez-Reed has. She's also, and the state really didn't touch on the separate Ellington trial, Judge Ellington trial, but that is a very real concern of hers, that if she's asked on cross-examination questions related to that, it really imperils her ability later to defend herself in that proceeding. So
basically the notion is that, everyone's going to hear what she says, and therefore they're going to convict her on the bringing a gun out at the bar. The problem is that the bringing a gun out at the bar, I think she's in some real difficult scenarios because she filmed herself bragging about having the gun at the bar, which is really the worst kind of evidence. So, yeah.
We'll have the appeal, Your Honor, which we don't know what will happen on that, but if it's remanded, the state gets a complete opportunity to cross-examine
Andrew,
or
you make me
examine
sad.
Ms. Gutierrez-Reed on matters she would have never had.
And Andrew, if I'm doing gavel to gavel coverage, I probably won't also be able to do recaps because I would die. So, yeah.
To say going into that trial. So while the unquestionably has the discretion, I would submit, Your Honor, that because she is unavailable,
yeah, that's not going to happen.
Statements can be introduced by both parties. There is another way the court can handle this and avoid the potential constitutional issues that may arise in the future with her right to a fair trial in front of Judge Ellington and perhaps in front of this court if the appeals court reverses this case. So I think there's another way this.
All right. So how does the court deal with all of this? Because they've got their little headaches on all of this. So she's got a ruling.
All right, the court makes the following ruling to be followed up by an order of the court to be filed next week. The state denies the state's amended opposed expedited motion for use immunity for Hannah Gutierrez. It's pretty clear that she does not intend to cooperate. The court may grant use immunity pursuant to Rule 5116 if the court finds the testimony may be necessary to the public interest and the person has refused or is likely to refuse to testify. So it's really the public interest portion that I'm going to address because she has indicated that she won't testify.
So basically, she refuses to grant the use immunity on the basis that Hannah Gutierrez does not want to testify. And
you've indicated that she possesses information about what she already told the investigators. I don't think that there is anything that, I mean, I haven't heard of anything that she might testify to that someone else could not testify to, even about her observations. Maybe, I mean,
she's saying use another witness if you can. Use another witness if possible.
maybe the only portion is that talking about how Mr. Baldwin didn't want to be trained, things like that, which she could probably answer without the use immunity.
And she also says she can probably answer things about Baldwin not wanting to testify without the use immunity. Okay, here is where this is going to be a clusterfuck. This is going to be an absolute disaster. And I guess I can roll this just to explain why I'm okay with using that. So, here's why that's going to be a bit of a clusterfuck. Because she doesn't have the blanket use immunity, what it means is that every time she wants to assert the fifth, they may end up in an argument over that, right? They may end up in an argument over whether each individual question is something that she can assert the fifth over. And there is a very real possibility that they just spend that like so much time over that. So, yeah.
But, the state says, well, the simple solution after she refuses to answer, even though she's been given immunity, is that you can hold her in contempt. I'm not going to do a mini trial within a trial. And I think that when all is said and done,
she's saying I don't want to be holding her in contempt each time because then I have to have a contempt hearing. Because she's going to follow due process for contempt, unlike the YSL trial.
and if she's going to be an unavailable witness, then we're at the 11804 evidence rule on unavailable witnesses.
So that rule basically is that you can sometimes get hearsay evidence in where the witness is unavailable, right? So usually that can be used in circumstances where where like a witness dies or something, but they may say she's unavailable because she's pleading the fifth, therefore we're putting her statements in. So, yep.
So I think you should prepare accordingly.
Prepare accordingly means get ready for those arguments.
If I could just ask a point of clarification.
Yes.
Given that the court is denying the motion, the state still can ask questions of Ms. Gutierrez that do not trigger her Fifth Amendment privilege. So we can still have her transported. We can still put her on the witness stand. Does the court want to deal with what questions she has? She has the right to assert the fifth to prior to trial, or do you just want to wait and do it then?
Right. I mean, I'm forecasting based upon what Mr. Bowles is saying, based upon that interview, that everything is going to be a non-answer, and then there's the unavailability of the witness.
So basically, she's gonna bring Hannah out anyway, or at least that's where it seems to be going. So that is kind of expected. Okay, let us jump ahead here. That one is done. That was Morrissey's motion to give her use immunity. Morrissey loses this one. So if you're keeping score, 1 point for Morrissey, 1 point for the defense. Moving on.
Believes your facts about the armor and David Hall's and that he had every reason to be able to rely on them, and the state's alleged.
All right. Actually, I should also cover some super chats here while we can. The Green One Mischief, thank you for the YouTube membership. Rainman YYC, thank you for the 10 gifted memberships. Paladin Phil, booger hooks off bang buttons, people. Yep, we'll talk about that too. John Coman, keep your booger hook off the bang switch. Yep. Cootie Pootie Tootie for the Comes Now Videography Fund. Thank you. Just because, but Runkle, he was paying for the movie. Yeah. Hope, reckless and arrogant, and zero care for others' safety. Yep, Justin Wright, in Army basic training, the only times drill sergeants were officially allowed to lay hands on trainees was during weapons usage. My drill sergeant got a lot of stress out on range days. Trainees are very dumb. Yep. I can tell you, I've laid hands on people when I was teaching them gun things, just to be like, grab, plant, right? If somebody's about to do something dumb, grab the arm, grab the gun, prevent them from doing the stupid thing. The Mom Zombie, thank you for the YouTube membership. Dirk Schwartz, it's hard to ignore sophisticated trolls. I am trying hard too. I was failing a lot. Steve A, I don't even keep my finger on the trigger of a drill. I do the same thing. It's a gun owner thing where you just keep your fingers off of that. So Scott Roche, thank you so much. H2HMGHB, when your finger indexes on a squirt bottle or drill or other objects, you've been doing it for a long time. Not period correct, but correct safety. Yep, absolutely. Banny, thank you so much for the 10 gifted memberships. John Coman, stop, Runkle. You're raising my blood pressure. Cat in Virginia, thank you for the super sticker and the picture of the cat in Virginia. Mildred Katie, Brandon Lee died on a set more devoted to safety. Absolutely. Brandon Lee's was a complete tragedy. This one is just a catastrophe of people not giving a damn about safety. Witchy Jesse, thank you for the 5 gifted memberships. Lisa BS, could they get some of this in as to the history of the gun to show that it wasn't faulty, as it didn't go off by itself when doing all this crap? I'd certainly argue it. Cat in Virginia, thank you for the super sticker. CGR 902, one might say that the accident was disarming. Rainman YYC, referring to the guy who lost his arm. It's kind of terrible, but kind of funny. Rainman YYC, reckless would be me driving post-stroke without doctor's endorsement. Any accident would be automatically deemed recklessness. Maybe. It depends. Alan Michael, HG would have got time served. It wasn't for her mouth. Yep. Florida Red Wolf, actor with concealed carry here. You're correct. Thank you so much. Canonical Heat, thank you for the 20 gifted memberships. Much appreciated. Rob Smith, just a deposit in case I need your assistance someday. Lol. That is not a retainer. Matt Gear, thank you for the YouTube membership. Pampered Shelley for the new microphone fund. I may need to buy one. Thanks for keeping us updated and entertained. Thank you. Linda Santiago, always good to have a Runkle night. Thank you. Lindsay Ella, thank you for the YouTube membership. Much appreciated. Krista Bolster Robichaud, I was on replay crew for your birthday video stream when you came on live today. Lol. So cool to watch you in action. Well done, Runkle. Thank you so much. Runkle 3 days in a row. We know you don't sleep, but appreciate your time, effort, and dedication. After this, I might try to make it out to the leather workshop. Tai Mao, I still laugh at the episode of Law and Order SVU where a person in deep cover pled the fifth on her name. It was a confusing episode and an edge case that made little sense to me. They don't always follow strict law. Goose, I'm behind, but right-click to change speed in VLC. Thank you so much. And Sonny or Chris, Mamma Mia, that's a spicy meatball. Fair. All right. Let's keep going here. During range days, violators were given a choice: paperwork, i.e. written up and court-martialed, or participate in Gunny's physics experiment to move the Earth 1 inch away from the sun. Okay. Let's keep going here.
Facts that he was a producer. He knew about, he should have known about the armor, all these things. I'm not getting into whether it's true or false.
Okay, so we're going to go back here. So they brought a motion to dismiss on the basis of cannot possibly prove anything. So basically they argued that there was, and that's this guy. This guy also looks kind of creepy, but yeah. So they argue that it can't possibly be proven because there's just no evidence to establish anything. And then we're going to see the ruling on that. So
criminal negligence as existing when a person acts with willful
Well-
disregard of the rights or safety of others and in a manner which endangers any person or property.
I suppose it'll help if I actually show you the guy. This guy. This guy.
Was loaded with live ammunition. So give them everything else they say. Give them the disputed facts. They don't dispute that. It's clear on the face. Pages 14 and 15 of their op. They do not dispute that.
What about the disputed facts? You talked about that they've raised additional facts. What about all the case law that says if you have disputed facts, it's for the fact finder? It is not for the court.
Your Honor, that's true only where the disputed facts, if resolved by the fact finder in favor of the state, could satisfy the elements of the offense. Our submission today is that assume the fact finder resolves every disputed fact in the state's favor. They do not contend he was subjectively aware that the gun in his hand could kill somebody, because they don't contend that he was subjectively aware that there was any substantial risk that it had live ammunition in it. So give them.
Okay, so subjective awareness. Subjective awareness is different than objective awareness. And what subjective versus objective becomes complicated. So, let's consider an example here. Objectively, a reasonable person should assume, like, let's say, if you're driving a car, it's probably objectively reasonable to know that the emergency brake is a brake, right? That if you pull up on the emergency brake, that it's going to stop the car. But let's say, and so if the test is objective knowledge, then everybody is deemed to basically know that, right? But let's imagine that the test is subjective knowledge. And so you've got this guy who is the world's biggest idiot, right? And he's driving along on the highway and he sees a lever in the car and he's like, I don't know what this does. And he yards on the lever and somebody smacks into him, right? From behind, because he's just hammered on the emergency brake. But it turns out this guy is the world's biggest idiot, right? He doesn't know how this works. And him specifically, he just doesn't know. So, subjectively, if the test is subjective knowledge, then he walks, because subjectively he didn't know. This becomes relevant for all sorts of things, right? Like, you know, did you know subjectively that you shouldn't put bleach in your boss's coffee? Objectively, you ought to know that. But subjectively, did you know that? This is why there's a lot of things that have objective tests, right? So
Everything else they say, give them they pulled the trigger. Give them he didn't attend the safety check. Give them all that for the purpose of this motion. Assume the jury resolves all of that in their favor. They still can't meet the elements of the offense. And that is the essence of a full and fine. I would call it a Pacheco motion, because Pacheco really refined the standard. But that's the essence of the motion presented to the court right now.
All right, well, let me read from Henley, because you read a certain portion of Henley, but there's more to Henley. And it says, criminal negligence required for involuntary manslaughter for a jury instruction includes the concept of recklessness, in which a defendant consciously disregards a substantial and unjustifiable risk that harm will result from his conduct. The Uniform Jury Instruction on Criminal Negligence incorporates this definition, defining criminal negligence as existing when a person acts with willful disregard of the rights or safety of others and in a manner which endangers any person or property. UGI 14133. Likewise, the instruction on involuntary manslaughter states that the defendant should have known of the danger involved by his or her actions. 14231. To be convicted of involuntary manslaughter, a defendant must have been aware of the risk caused by his or her conduct and continued to act. So I'm curious as to how you're narrowing that, because they're broadening that. And they're saying, look at all this other evidence that shows that he should have known. Number one, he had a bad armor that he's responsible for hiring. He should have known that she was a bad armor. Number two, he was aware that Halls periodically checked the gun, which implies that he also knew that he didn't check the gun from time to time. I'm trying to remember what else. The SAG guidelines that they don't completely rely on, and I think you said that they rely on. If you said completely, they rely on them in part, and they're saying that as an actor, he, despite all that other information, that as an actor, he is not supposed to be pointing a gun at someone. And there's no need to use the gun, and that he pulled the trigger when he was pointing a gun that he didn't need to point to. So I'm curious as to how you have limited it to he has no knowledge because he got to rely on his armorer, he got to rely on.
You're probably right.
David Halls,
it came up in my.
And you're ignoring all this other information that circumstantially, which is allowed, would indicate these elements, and that seems to be the core of what the jury is going to decide. And I'm not clear on how you're reconciling these kind of cases. A defendant's not, in fact, in Murrieta, which you rely on very heavily, it says, State versus Murrieta. Defendant's argument both below and on appeal amounts to a disagreement as to how the fact finder should interpret the facts alleged. Such interpretations benefit from the opportunity to observe the testimony of witnesses, judge their credibility, weigh the evidence, and hear the parties' arguments after the close of evidence as a jury would have. Such contested facts, questions of fact in criminal cases rest within the exclusive province of the jurors. And then also in Murrieta in paragraph, that was 17 in paragraph 18. Furthermore, defendant's knowledge of intent generally presents a question of fact for the jury to decide. So to me, and you did acknowledge that they added, that they have additional facts. And under the case law that I'm reading, additional facts can equal disputed facts, and if you have disputed facts, you don't get full and final. And these additional facts are disputed facts, regardless of whether the state says, well, these other ones we dispute now. I'm just concentrating on the additional ones. And to me, it seems that this is at the...
Basically, they were just saying, hey, there's a bunch of factual arguments. And because there's a bunch of factual arguments, then we can't dismiss it. Because the factual disputes would be enough to establish it. Somebody said, what was I watching? Somebody sent me a link to the Turtle Boy video, and I was like trying to click through and sort of go to the next thing, and I clicked and it started playing. So I was like, nope, stop that. I'll watch it later, but I haven't watched it now. Sad Tiger, Mrs. Runkle would agree with you, but you are both wrong. Mushrooms should be on a pizza. So, yes. Somebody says it thought it was meth addicts fighting. Okay. Kind of does sound like that. So, yeah, she refuses to grant that on that basis. She says that the disputed facts need to go before the jury.
Does not claim that you have a subject to sit here and say they can dispute that. There's a reason she did defense.
The court finds that, first of all, there does exist disputed facts before the court that are not capable of dismissal as a matter of law. The disputed facts are appropriately before the jury. The involuntary manslaughter talks about the defendant should have known of the danger, and I think that's really at the core of what is argued, that Mr. Bash is saying there's no way he could have known, so there's no way he should have known. And Ms. Morrissey is saying here is some circumstantial evidence as to how or why Mr. Baldwin should have known. With respect to the
so I also just got to say, people talking about pizza toppings. Now you're making me hungry, but the pizzas I like, I bet you would not specifically like, I suspect. So, I like things like Kalamata olives and anchovies. When I get a pizza, it tends to be a pizza that, what is it? It is definitely anchovies. Part of why I eat the pizzas that I eat, and is I got into the habit of ordering like weird pizzas, in part because so when I was articling, I would go and I'd order a pizza for me for lunch. Like I did that once as I did that as like a treat for myself every once in a while. And so I would order a pizza, and then I'd ask if anyone else wanted to order a pizza, and they would say no. And then when the pizza came, everybody wanted a piece. So I started ordering things like oysters and artichokes and olives and anchovies, and I would get a pizza that I would love and that nobody else would eat. And so then people would come by and they'd be like, hey, can I have a piece? And I'd be like, you bet. And they'd be like, what kind of pizza is it? And I'd tell them, and they would walk out without any pizza. So it worked really, really well. Sarah was asking, does Mrs. Runkle love my pizza toppings? No. When Mrs. Runkle and I order a pizza, we either order one that we both like, which is usually like a Meat Lovers or something like that, or we order separate pizzas. And so she gets her pizza, I get my pizza, and it works out.
Consistent theories of prosecution, you didn't really bear that out. I don't think you've met your burden. I think that the 10th Circuit, U.S. versus...
All right, so the inconsistent theories of prosecution. Basically, their argument was, at Hannah's trial, they said it was just Hannah's fault and that Alec Baldwin was a complete idiot and couldn't be trusted to anything. Whereas now they want to say that Baldwin was a critical feature of the safety, of the safety system. So she rejects that. She doesn't allow that, or she doesn't go with that. Now, okay, what happens after the break? Well, we're going to skip over a lot of this, but this is the gun. Now, I'm just going to note, I have the same gun, except mine has an octagonal barrel as opposed to the round barrel. But it's the same function of the gun. It's the same. It's a Pieta. It's the same year. It's every way the same. So what is the defense argument? The defense argument is that the case needs to be thrown out, discharged entirely. And Mari M., I ate a lot of kimchi, fermented squid, fermented stuff in general in college to avoid losing it to pantry bandits. I've never been a pantry bandit, but you would have tempted me to be a pantry bandit with kimchi and fermented squid and fermented stuff. Yeah. Is that the biggest gun? It's the biggest gun the armorer had. There are bigger guns. So, anyway, the argument is that the government destroyed this gun. And what I mean by destroyed this gun is that they sent it off for testing to see if it could go off accidentally. And that testing involved pounding on it with a hammer, with a mallet. And the mallet eventually broke the sear of the gun. And the sear of the gun is the, is the thing that basically prevents the gun from firing except when you pull the trigger. That eventually broke. Now, the reason why the defense is upset is they're saying this was destroyed and we wanted to explore a theory. They said we wanted to explore the theory of whether this gun was modified in a way that allows it to fire more easily than it ought to. And so one of the questions they ask the experts, because they go through all the witnesses here, and they have Lucian Haig on the stand for forever. One of the things that they sort of go after is the trigger pull on the gun. And the issue is that the trigger pull on the gun comes in at around 2 to 2.5 pounds. Now, you might be saying, what does that mean? Well, if you take the gun and you point it upwards and you put weights on it, when does it go off? That's sort of how you determine the pound weight of a gun. So, now, trigger pull varies. So, police typically carry guns, handguns, with very heavy trigger pulls. You'll see trigger pulls of like 10 to 15 or more pounds on police guns. And the reason why is because they don't want you to, like, they don't want police guns to be on hair triggers. They want it to be on a trigger that requires an intentional pull. Now, I will say that I have a rifle that has a trigger that's like a typewriter key. You barely have to pull it to make it shoot. There's a wide range, right? And so in this case, they come in at 2 to 2.5 pounds, which is a fairly light trigger pull, but not what I would call a hair trigger. Hair trigger, I would typically say, is the kind of trigger where you touch it and it goes off. Now, how do you measure trigger pull? Well, you can either do the thing like where you have it, up and you literally pile weights on it, or the better thing to do is to use this thing. This is a trigger pull gauge, and it works like this. You extend it up like this, and then you take this bit and you hold the gun steady, you hold the gun firm, and you turn this thing on and you pull it until the trigger fires. So, I had this thing and I had it on in the maximum minimum mode. And so what that means is that it basically shows me, if I do it repeatedly, it shows me the maximum trigger pull for that gun and the minimum. And I did it on the same gun. And I can tell you that my trigger pulls on that range from 2 pounds to 3 pounds. Maybe a little over 3 pounds and a little over 2 pounds, but a little over 2 pounds to a little over 3 pounds. So when they say that the 2 to 2.5 pounds is consistent with this gun being in its original configuration, I go, seems right to me. Seems right to me. Now, they said that single action revolvers, they brought in some data from a study that said that that basically it is often more like, 4 to 5 pounds. Well, different single action revolvers are going to have different trigger pulls. And so this particular model of revolver appears to have a fairly light trigger pull. And I can note, I actually have commented in other videos on the light trigger pull inherent to this gun, because I noticed that when I shot it. I noticed that it was a very light trigger as compared to some of my other guns. So I'm not going to show you any of the other guns because we're on a live stream. I can't do that. But yeah. Spam is a pretty popular thing in parts of Asia and Hawaii. I will tell you, I really actually like Spam Musubi. It's really good. My wife and I make that before. So yeah. And yeah, it's well known for being a light trigger pull, isn't it? It is. By the way, Spam Musubi is basically take Spam, fry it with soy sauce and some other stuff, and you end up with like little strips of fried Spam with like some umami addition to it. Throw that on little blocks of rice, and it's really good. So I kind of like Spam. Oh yeah, Korean Army kimchi stew with Spam is also pretty great. Korea makes there's a Korean dish which is basically like Korean Army soup, and it is it has spam in it. It has all sorts of things, and it is delightful. It is delightful. And Baldwin should know how light the trigger is, considering he'd fired blanks for the movie. He'd used that gun a bunch. He would have known for sure. So now this this argument took about 6 hours, and they're not done. They're not done with this argument. They're still going. So let's look a little bit at the end there. Mr. Haig was having some tech troubles.
That's true.
We're back to the same problem. I'm missing a word here and there. Sandy, do you mind if my wife stands here and sees if she hears it? Can't do that, eh? Okay. Judge says no, Sandy, go away.
Judge says no, go away. You know what? I'm sure they have a great relationship, him and his wife. I'm sure they do. But that was still funny. Judge says no, Sandy, go away. Yeah. Also, I love the guns in his background here. He's got a lever action. He's got a flintlock. I don't know what the third is, but I kind of want to just visit this guy and see his gun collection so much.
Hold
Your
on,
Honor, I don't.
hold on,
Sorry.
folks.
Yo, Ian, I was a lawyer for about 5 years and quit like they told us most of us would on our first day of law school. I really appreciate your coverage and keeping us law nerds informed. Thanks. It's a tough job, and I got to say, I thought about quitting, but I'm glad I've stuck with it. Are those posters of a Makarov and an AK in his background? Yep.
That's what you want to do.
Trigger pull measured the same at every position. If you mean every cock notch position, it only actually fires at one of them. So, yep.
As I've indicated, Your Honor, we're not going to be able, the defense is not going to rest today. So I would ask, and I understand, and I say this genuinely, the court schedule and fitting this in where we are in the lead up to trial, but the issues are just serious, and I'm not going to be able to rest today. So I would ask, even if we don't just...
Sir, get a better setup. Get a better setup, because this makes you look like a creep. If you don't set it up properly, you look like a creep. So get your lighting sorted out. Get your video sorted out so it's not like right nostril cam.
At this exact moment when there could be potentially another hour from the court. But given the hour, given the ability to cross-examine this witness, and given that there's going to be other documents and evidence that we have to put in because of what's going on here today, we're not going to be in a position to rest today.
Can I ask, does the defense have other witnesses that you intend to call?
So I have to meet with my
Ask?
I like this. Watch her face.
and evidence that we have to put in because of what's going on here today. We're not going to be in a position to rest today.
Watch her face.
Can I ask, does the defense have other witnesses that you intend to call?
She's like, do you have other witnesses? She does the mugging it. I'm like, wow, okay.
I have to meet with my colleagues after this and decide, given what I think is going on here, which is troubling, to put it lightly. So I don't know exactly how this is going to proceed. Having practiced in many, many states, it's very rare that I'm put in a position where...
I'm just going to note, with the defense attorney and the Hitler mustache, it's lighting. He doesn't actually have a Hitler stash, but when your lighting makes you look like you might have a Hitler stash, maybe fix that, because under no circumstances should anybody be looking at you as a lawyer and going, oh, right, it kind of looks like he's got a Hitler stash, right? Do not do not do that, right? Yeah.
Reports are hidden. Witnesses change their answers in this kind of manner. And I hope the court will take this seriously. We're certainly taking it seriously. And I just cannot be in a position where we don't have a moment to confer and the court looks at me an hour past the end of the day and says, can you just rest? I'm not going to do that. I'm going to ask for more time. So I'm just being direct with the court on where we are.
Well, that's not really germane to my question. My question is, we showed up to do a hearing today. I understand Mr. Spiro's concerns, but if the court tears a hole in its calendar and resets us, is the defense then going to show up with witnesses that we haven't interviewed?
Let me do this. Your plan, Mr. Spiro, was that you were going to.
So the judge is just like, you guys are getting all set to have a fight, and I'm just gonna stop your fight right here. She's just like, we're not having this argument. We're gonna do something else entirely. And
use these 3 witnesses. And now I don't understand how because he can't remember, you're going to be calling other witnesses. These are the 3 witnesses for this hearing. I am going to call this hearing again at 2:30 on Monday, and it's going to end at 5:30 no matter what.
So she's like, so the thing that was very troubling to Mr. Spiro was that the defense expert there, Mr. Haig, was having trouble remembering some of the meetings he had before. And so he's trying to cross-examine them. And they're like, do you remember this meeting? And he's like, nope, I don't remember it. And he's like, well, but you were there. And he's like, yeah, but I'm old. I don't remember it. So, okay. He's very bothered by this. And he says, I need to call more witnesses. We're going to make this into a big old production. And the judge is like, no, you said you were calling 3 witnesses. You're still calling only those 3 witnesses. That's it. That's all you get. And we're going to call this on Monday, and it's going to be done by 5:30. So you're getting 3 hours on Monday, and that's it. That is it. That's over. So they're gonna finish that up on Monday. We're gonna get a ruling on the defense motion to throw this out on the basis of the destroyed evidence. Now, I want to note clearly the defense thinks this is their best motion because they are spending hours on this as opposed to the other motions. Clearly, they think this is their best chance of getting this thrown out before trial, right? So cool. I don't think they're going to, but they're trying. They're trying. So all right. That's about what's happened. That's got us all caught up. Oh, yes. I just remembered the gun expert for Hannah Gutierrez Reed. It's not the gun expert for Hannah Gutierrez Reed, but I do still want to make another video mocking that guy because he deserves it. Dina Kawaji, thank you for the gifted membership. Froggy Girl, my husband asked me why I don't watch show like Law and Order, Bull, etc. I told him I like to know what can really happen. Facts, not fuckery, babe. I agree. Gil, holy crap, Gil. Thank you for the 50 gifted memberships. That is tremendously generous. Thank you so much. All right. Let's wrap this up here. Ian, some enterprising lawyers should offer tech courses for law firms. I should really put out like a consulting shingle for that because yeah. It's bad. So yeah. All right. I'm going to wrap this up. I'm probably going to play a little bit of Hitman or go into the leather shop to do some leather working or something. Darth Rancor, thank you for the new membership. So thank you guys all for joining me. And Oh, Heartless Soul saying here from EDB's channel. Thank you for popping in. I will be doing a recap tomorrow for Karen Reed, because they're back again tomorrow. So we'll just do what we can. So I don't think it's his fault because he's traveling. Get a travel setup. This is going to be the shortest Runko live in like 6 months. You're sort of right. I have not played Elden Ring, so I'm gonna play Hitman is what I'm planning to do. So all right, let's roll the outro, and I'll see you guys tomorrow. I'm gonna try to get some sleep, so I'm fairly well rested too. Good night, everybody.